If you are filing a petition, application, or request with USCIS, you should be aware that it appears that USCIS is enforcing a harsh 2018 policy that could affect your case. For many years, USCIS had the policy of issuing a request for evidence or a notice of intent to deny if there was a problem with a submitted immigration case. For example, if an applicant submitted an adjustment of status package and did not turn in a required form or required piece of evidence, USCIS would send the applicant a letter called a request for evidence or possibly a notice of intent to deny. This letter would note the problems with the documents, and the applicant would be given a certain amount of time to correct the problem. If the required evidence was submitted in a timely manner, the case would simply proceed. This had been standard procedure for many years. In late 2018, USCIS changed its policy concerning the issuing of requests for evidence in these cases. Starting then, USCIS would have discretion to deny a case missing evidence. USCIS said that the policy change was done, among other reasons, in order to discourage skeletal applications used to game the system and to discourage the frivolous filings of petitions. This 2018 policy replaced the 2013 policy, which allowed a poorly filed case to receive a request for evidence, giving the applicant a chance to correct the petition unless there was no possibility of approval. This is key. The no possibility of approval language in the 2013 policy limited the discretion of USCIS officers to deny cases. In the past couple of weeks, we have received at least 2 calls from potential clients asking for help. In these cases, the potential clients had prepared and submitted adjustment of status packages to USCIS alone or with the help of a non-attorney. In these cases, they had failed to understand the confusing and sometimes contradictory directions on the forms, and they failed to submit the necessary forms with their applications. Their overall cases were fine, and it would be expected that the cases would be approved if they proceeded to the interview stage. Had the cases been filed prior to the USCIS policy change in late 2018, they would have each received requests for evidence and a chance to correct the shortcomings of their petitions. Instead of the requests for evidence, USCIS issued denial letters for the I-485 portion of their cases. While they can appeal their decisions, they are both likely to have to fix the problems and refile their cases. To make matters worse, USCIS cashed their checks of $1,225, and it is very unlikely the fees will be returned. Again, since late 2018, USCIS has had a policy which allows immigration officers to deny outright any visa or green card application that is missing evidence or contains an error, without giving applicants a chance to fix it. As our office had not received a denial on one of our filed cases, it appeared to us that USCIS was perhaps not enforcing this policy. However, as the last week has shown, this is not the case. In conclusion, it appears that USCIS is no longer taking a gentle stance with the cases that are filed with them. Keep this in mind when your case is being prepared for filing. Will USCIS change this policy in the future? We will see. Stay tuned. If you learned something from this video, please smash the like button, as it does help with the YouTube algorithm. Also, consider subscribing, as we will be coming out with other immigration videos in the future. The law offices of Lawrence Gruner has handled immigration cases for over 25 years and has 5-star reviews. We handle cases worldwide. If you would like a consultation, please call us at 888-801-6558 or email us at attorneygruner@gmail.com.